Hello, guys. Thanks for tuning in. I welcome all of you to my YouTube channel, Legally Determined. My intro: I am a practicing advocate in New Delhi and have been running a law firm in the name and style of Sanpa and Wycombe. Sanpa and Wycombe is a full fledged law firm. I am a dyed in the wool advocate who knows how to make a blitzkrieg in the court of law and knows how to knock his opponent into a cocked hat. I have crafted a high quality wit to hook my viewers and keep them viewing. I inter alia advise on corporate law. In this bull session, I would demystify the incorporation of foreign companies in India. I want my viewers to stick around for the entire episode. Across this way, my opinion matters because I am an advocate and have chops in this arena. This week's target audience are corporates, lawyers, advocates, judiciary, chartered accountants, company secretaries, or anyone fascinated by this hobby horse. My viewers will benefit galore from this episode. Please like, share, comment on and subscribe to my page. Disclaimer: this full session is for the purpose of education only and is not a replacement for specific legal issue. We suggest you seek out the help of advocates with your specific issues. Without further ado, let's dive into the episode. Foreign companies in India and the compliances under Companies Act 2013. We shall take the opportunity to provide the glimpse of basic definitions that will be helpful in better understanding of the concept. Company, Section 2, Clause 20. Company means a company incorporated under the Companies Act 2013 or under any previous company law. Body corporate, Section 2, Clause 11. Body corporate or corporation includes a company incorporated outside India but does not include a cooperative society registered under any law relating to cooperative societies and any other body corporate not being a company as defined in the Companies Act 2013, which the central government may by notification specify in this behalf. In a very general sense, a foreign company is a company which is incorporated outside India but has its place of business in India. Under Section 2, Clause 42 of the Companies Act 2013, a foreign company means any company or body corporate incorporated outside India but which has a place of business in India, whether by itself or through an agent physically or through electronic mode and conducts any business activity in India in any other manner. Let's compare the definition of foreign companies under the Companies Act 1956 and the Companies Act 2013. Section 592, Clause 1 of the Companies Act 1956 states that foreign companies shall mean the following two classes of companies: companies incorporated outside India, which after the commencement of the Companies Act 1956 establish a place of business within India, and companies incorporated outside India which have before the commencement of the Companies Act 1956 established a place of business within India and continue to have an established place of business within India at the commencement of the Companies Act 1956. Section 2, Clause 42 of the Companies Act 2013 states that a foreign company is any company or body corporate incorporated outside India which has a place of business in India, whether by itself or through an agent physically or through electronic mode, and conducts any business activity in India in any other manner. Let's analyze the difference of the meaning of foreign company between the Companies Act 1956 and the Companies Act 2013. The Companies Act 2013 has broadened the scope of the definition to include foreign corporations and strengthened the compliance requirements. The new meaning of foreign companies under the Companies Act 2013 incorporates body corporates just as companies in the definition, as the prior act alluded to just companies and not body corporates. The Companies Act 2013 eliminated the necessity for a physical presence in India to do business in order to be classified as a foreign corporation as required by the previous act. Now any entity with a virtual presence would be subject to the provisions of Companies Act 2013. Electronic mode. Electronic mode means carrying out electronically based whether main server is installed in India or not, including but not limited to business to business and business to consumer transactions, data interchange and other digital supply transaction, offering to accept deposits or inviting deposits or accepting deposits or subscriptions in securities in India or from citizens of India. Financial settlements, web-based marketing, advisory and transactional services, database services and products, supply chain management, online services, marketing, telemedicine, educational and information research and all related data communication services, whether conducted by email, mobile devices, social media, cloud computing, document management, voice or data transmission or otherwise, shall be deemed to have carried out business in India. Now let us analyze it further with the help of some pragmatic examples. Example 1. Amazon LLC, a company incorporated in the USA, is doing e-commerce business and selling its products through online medium in India. Example 2. Kirloskar LLC, a company incorporated in the USA, is in the business of providing consultancy services relating to engineering solutions. During the financial year, it gives its only consultancy in India to Mr. X Kirloskar LLC, charged Mr. X 50,000 rupees for the consultancy. Example 3. ABC Software Solutions LLC, a company incorporated in the USA, is in the business of providing software solutions wherein it provides online access to the software developed by it to its customer. and charges them appropriate amount for it. During the financial year, it sells usage right of its software in India only to Mr. B and charged him 10,000 rupees. The aforesaid companies are termed as foreign companies. They are not required to comply with the requirements set out in the Companies Act 2013. For foreign companies, the Companies Act 2013 contains certain provisions which lays down certain conditions which, if met, and then only such foreign companies will be governed by the provision of Companies Act 2013. It means if the conditions are met, then these companies will be required to comply with Chapter 22 of the Act, the governing chapter, regardless of their turnover. Applicability of the Act on foreign companies. Chapter 22, Sections 379 to Section 393, Section 379, where not less than 50%, namely 50% or more of the paid up share capital, whether equity or preference or partly equity and partly preference of a foreign company is held by one or more citizens of India or by one or more companies or body corporate incorporated in India or by one or more citizens of India and one or more companies or body corporate incorporated in India, whether singly or in aggregate, such company shall comply with the provisions of this chapter and such other provisions of this act as may be prescribed with regard to the business carried on by it in India as if it were a company incorporated in India. Analysis of the above section. Not all foreign companies are required to comply with the provisions of Chapter 22. Only the foreign companies whose at least 50% paid up capital is held by one or more Indian citizens or one or more companies or body corporate incorporated in India or jointly by the both are required to comply with the provision of this chapter. Different situations can be 50% or more holding by Indian citizens, 50% or more holding by Indian companies, 50% or more holding by both citizens and companies in any proportion. The applicability of the Act on such companies can be summarized as a 3 steps process as follows. Determine if it is a foreign company, see its shareholding pattern, decide based on the steps above if it is covered by the provision of Chapter 22. How to register a foreign company in India. Registration or incorporation for any of ways of doing business in India by foreign companies varies. Many professionals are involved in this matter as there are various important aspects which are kept in mind while starting the business, who explain all the pros and cons of how to enter in India and which mode is more beneficial for different types of business. What are the ways through which a foreign company can run business in India? A foreign company which is desirous of entering and doing business in India can enter many of below given ways. As an Indian company, when the shares of an Indian company are held by foreigners in below given ways. wholly owned subsidiary. For an Indian company to become wholly owned subsidiary company of a foreign company needs to invest 100% FDI in that Indian company through automatic route for the purpose of foreign company registration in India. Joint venture. It is important for the foreign company to elect a local partner with whom it wants to enter into a joint venture. A memorandum of understanding or a letter of intent is to be signed, which will state the basis for the joint venture agreement. A thorough discussion of all the terms should be done, and they must be consistent with regional as well as international law. Subsidiary company. In this, the foreign company holds shares of Indian company up to the limit of 49.99% of the total shares of the company. As a foreign company can register under the Companies Act 2013 to start business in any of below given ways. License offices can be established for all license activities in India. All the expenses of the license office must be met through foreign remittance from the parent company. On the other hand, the project offices can be established to execute projects awarded to a foreign company by an Indian company. Approval from the Reserve Bank of India may be required. Compliances for foreign companies under Companies Act 2013 and Companies Registration of Foreign Companies Rules 2014. Every foreign company is required to submit these documents to the registrar for registration within 30 days of the establishment of its place of business in India. Certified copy of the charter, statutes, or memorandum and articles of the other company or instrument defining the constitution of the company, and if the instrument is not in the English language, a certified translation thereof in the English language. Full address of the registered or principal office of the company, list of the directors and secretary of the company, containing such particulars as prescribed under Rule 3. Fourth, name and address or the names and addresses of one or more persons resident in India authorized to accept on behalf of the company service of process and any notices or other documents required to be served on the company. Full address of the office of the company in India which is deemed to be its principal place of business in India. Particulars of opening and closing of a place of business in India. On earlier occasion or occasions, declaration that none of the directors of the company or the authorized representative in India has ever been convicted or debarred from formation of companies and management in India or abroad. Other documents as may be prescribed. Rule 3, Subrule 3 requires application in Form FC1 to be supported with an attested copy of approval from the Reserve Bank of India under Foreign Exchange Management Act 1999 and the rules and regulations thereunder, or a declaration from the authorized representative of such foreign company that no such approval is required. Rule 3 Subrule 4. Rule 3 Subrule 4 provides that in case of any alteration in the aforesaid documents, the foreign company is required to submit a return in Form FC2 containing the particulars of alteration as per the prescribed format with the registrar of companies within 30 days of any such alteration. Section 381 of the Companies Act 2013 states about the accounts of foreign companies. The foreign companies in each calendar year are required to prepare a balance sheet and profit and loss account, such form containing such particulars, and shall also annex the documents as prescribed under Rule 4 along with the balance sheet and profit and loss account. All these documents shall be filed with Registrar of Companies along with a copy of list of all the places where business has been established in India as on the date of the balance sheet in Form FC3. Section 382 of the Companies Act 2013 states about the display of name of foreign companies. Every foreign company is required to exhibit outside its every office or place of business in India and in all business letters, bill heads and letter paper and in all notices and other official publications the name of the company and the country where it is incorporated. The name shall be in legible letters of English language and also in the local language of the state where such office is situated, besides the name and the country of incorporation. The company is also required to mention the fact that the liability of the company is limited. If it is so. Section 383 of the Companies Act 2013, Service on Foreign Company, any process, notice or other document required to be served on a foreign company shall be addressed to the person whose name and address have been delivered to the registrar and sent by post or by electronic mode. The documents on foreign company as per the new act may now also be served by electronic mode. Section 384 of the Companies Act 2013 about debentures, annual returns, registration of charges, books of accounts and their inspection. Section 391, application of sections 34 to 36 and chapter 20 of the Companies Act 2013. The provisions of sections 34 to 36 of the Act, both inclusive, shall apply to the issue of a prospectus by a company incorporated outside India under section 389 as they apply to prospectus issued by an Indian company. The issue of Indian depository receipts by a foreign company. The provisions of chapter 20 of the Act Winding up shall apply mutatis mutandis for closure of the place of business of a foreign company in India, as if it were a company incorporated in India. Section 392 of the Companies Act 2013, punishment for contravention without prejudice to the provisions of Section 391, the Companies Act 2013. If a foreign company contravenes the provisions of this chapter, the foreign company shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 3 lakh rupees, and in the case of a continuing offence, with an additional fine which may extend to 50,000 rupees for every day after the first during which the contravention continues, and every officer of the foreign company who is in default shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 25,000 rupees, but which may extend to 5 lakh rupees, or with both. Documents required for registration of foreign company in India. Depending upon the way a foreign company starts a business in India, the documentation also varies. However, let us look at documents required in each way of doing business. Wholly owned subsidiary company. Number one, address proof of the office. In case of a rented property, the latest electricity bill. Documents submitted must be certified by the Indian consular or consulate. For Indian citizen, PAN card mandatory, address proof, photograph ID, proof like an Aadhaar card. For foreign national, passport mandatory, address proof, photograph ID, proof like any government license. Joint venture, dispute resolution agreements, law applicable, holding shares, transfer of shares, board of directors, non-compete, confidentiality, etc. While making investments in India, the foreign company has to abide by Indian laws and regulation. Furthermore, Foreign Exchange Management Act 1999 FEMA, post earning from business activities, the company also has to pay tax and comply with each law pertaining to them. I have made this vid off the hook. Thanks for watching this vid. Please like, share, comment on, and subscribe to my vid. Break a leg.